We've worked with hundreds of families navigating the probate process in California, and let me tell you, almost everyone starts with the same questions. Do we really need a probate? What even is probate? Can we skip it if there's a will? If you've been named the executor of someone's estate, or are you just trying to help a loved one get organized after a death? This video is for you. And in this video, we'll walk through the most common probate questions we get from clients who are just starting out. By the end, you'll understand when probate is required, what kinds of assets are affected, what happens if there's no will, and what you risk if you don't file at all. I'm Elijah Keys, certified specialist estate planning attorney. That means I'm like a board-certified physician, except I'm board-certified as a probate attorney. I have helped hundreds of families navigate through probate, and we're going to answer your most frequently asked questions. When is probate necessary? If you've been following our probate series, we've already gone over what probate is and when it's required. If you haven't seen those yet, I encourage you to check them out. You should be able to find them here. They'll give you a great foundation. But let's recap before we dive deeper. Probate is needed when someone passes away when there are assets in their name as loan, without a joint owner, without a beneficiary designation, no other way to transfer them, and if they're not held in a trust. In other words, probate is a court process that steps in when there's no built-in legal mechanism to move property after death. You might be thinking, but my loved one had a will. Don't we just follow that? Here's the key point. A will doesn't avoid probate. A will is like a letter to a judge. It tells the court what should happen, but you still need a judge to read it, approve it, and authorize those steps. Probate is the process, how all that happens. Now, if there's a living trust in place and all the assets are properly transferred to that trust, you might avoid probate entirely. In fact, most of the time you will. But if there's one asset left outside the trust that exceeds some magical threshold, then that will trigger a full probate. What amount triggers probate in California? In California, as of 2025, the probate threshold is $206,000. Now, you might see some sources that say it's $184,000, but that number changed April 1st. That's the level that's required for probate. That rule comes from Probate Code 13100. If you meet with me in person, you're going to find that I'm completely full of legal codes that don't have any practical purpose outside of this room. If the decedent's estate includes more than that amount in assets that don't have a beneficiary named, aren't jointly owned, or aren't held in a trust, probate is likely required. That includes things like a house in their name alone, bank accounts with no joint owner or pay-on-death designations, that's like a beneficiary designation, personal property like the things in your house, your jewelry, your personal items, or a vehicle or a mobile home. If the assets are under that amount, there are simpler alternatives like small estate affidavits. If you're over even by a little, the court will still expect a full formal probate. And that leads to the next question. What kinds of assets actually go through probate? The assets that go through probate are typically those that were titled only in the name of the deceased person, without a named beneficiary, and not transferred into a trust. So if your mom passed away and still had a house in her own name, or if your dad had a checking account with no co-owner, that's probate property. On the other hand, some things usually don't go through probate. Real estate that's in joint tenancy, life insurance policies with a beneficiary, retirement accounts like IRAs, 401ks with a named beneficiary, assets held in a living trust. And it's not about the type of asset, it's about how it's titled. If you're looking at the bank account or a piece of property thinking, do I have to go to court to access this? That's why having a professional review the title, that's the name on the owner line, and the documents about that asset is so important. It's not always obvious, but there's one thing that we have to add here. Remember before when we said that some things avoid probate just because they are the things that they are? Like a car or a mobile home or personal property or a bank account under $200,000? That only counts if there's no other probate. So if there's a house in someone's name and they have a car, the car goes through probate because the house goes through probate. The car only avoids probate if nothing else causes a probate on its own. $500,000 in a bank account with no beneficiary designation causes a probate, therefore the car and the mobile home go through probate. No bank account through a probate, car and mobile home don't go through probate. So if your loved one passes away without a will, does that change anything? What if someone dies without a will? Well, that's a common situation, and it can be stressful if someone passes away without a will. California's laws, called intestacy, which means dying without a will, decide who gets what. That doesn't mean the state takes everything, but it does mean that the order of inheritance is set by law, not by you. It means that the personal representative is not chosen by you, it's chosen by the court. That means that you still go through probate. If you have a will, you probably still have to go through probate. Now, that doesn't mean that you have a trust and you have a will that you go through probate. It simply means that a will directs the court what to do, and without a will, the court uses its default rules. So instead of following the decedent's written wishes, we follow a statutory or legally described formula. That's what statutory means. It means by statute or by law. And sometimes this creates tension, especially in blended families, estranged relationships, or where expectations might be different from the law. Let's talk about one of those expectations. If you have an unmarried partner, that unmarried partner has no legal rights to make decisions for you in any way. That person is not listed on the list of people who are entitled to make choices for you after you die. That means that if you have a cousin, a grandmother, a grandchild, a mother, a sibling, they have priority to make decisions for you, and they must step aside before the next person can serve. There's simply a list of priority by which people serve. It goes spouse first, then children, their grandchildren, then parents, then grandparents, and goes all the way down the line until we hit the final person on the list who is a creditor. Yes, Citibank can open a probate for you if you owe them money. A will allows someone to state their preferences. Without it, probate becomes not just a legal process, but a family negotiation. Let's flip the coin. Suppose you did find a will. How do you know it's valid? In California, a valid will must meet these basic requirements. The person creating it, also called the testator, must be at least 18 years old and of sound mind. Sound mind means they must know what they're doing and must have a certain amount of legal understanding. It must be in writing, normally typed, but handwritten is okay too. It must be signed by the testator. If it's typed, it must be signed by two witnesses present at the same time who watched the person sign it, or watched the person say, "This is my signature." Now there's an alternative, which is a handwritten will, sometimes called a holographic will. You can actually write a will on a piece of paper and it doesn't need to be witnessed, but that's not necessarily a good idea, because if you look at the case of Aretha Franklin, who had a handwritten will that she stuffed in her couch, that was a valid will, but no one knew that it was valid. Nobody knew that it was there, and the family litigated for 5 years. So to avoid litigation, holographic wills, often a bad idea unless it's an emergency. Sometimes, even after the will is created, changes are needed. And that's where codicils come in. So what are codicils? A codicil is an amendment to a will. It lets someone change part of the will without rewriting the entire thing. Now, if you come into my office, you're going to see that a lot of times I don't do codicils. We write the whole will. We have very high standards, but you can modify a will. For example, if your mom creates a will in 2010 and wants to change who gets the house, she could sign a codicil, making that change official. Here's the catch. Codicils must meet the same formal requirements as an original will. If they're done incorrectly, or if multiple codicils contradict each other, they can cause confusion, delays, or even litigation. In our experience, being clear and direct is almost always the right way to go. It is almost always safer to create a clean, updated will instead of stacking codicils over time. It oftentimes takes the same amount of time and effort to create a completely new will, and it's the same formalities to create a codicil as it is a will, and it's the same amount of personal effort from you to create a codicil and a will. Just create a new one. Let's close with one more important scenario. What happens if probate is required and no one files? What happens if you don't go through probate? This actually happens more often than you might think. If you're supposed to open a probate and don't, there are some serious consequences. For example, you can't sell or refinance property without proper authority. That includes a home, also brokerage accounts or stocks. Financial institutions won't release funds without letters of administration. We'll talk about what that is a little bit later. Title to real estate may remain uncertain. We're not sure who owns it, and we can't clarify without legal permission. You could face liability from heirs or creditors. You might even lose the legal right to administer the estate. There's a multiple number of people who can open an estate, and it doesn't have to be the person who's named in the will. If the person named in the will refuses to act, somebody else can open it. And that list of priorities is the same as we talked about in intestacy prior. If you're interested in that, go back to that part of the video. Probate isn't just a formality. It's what protects your authority and the estate's assets. Delaying it often creates more stress and legal hurdles later on. Here's one key example. I've seen lots of situations where families think, "Mom died, I'm owed the house under the will, I'll just wait for a long time because I don't actually need to do anything. And there's a huge problem with that. When property changes hands, it starts a huge chain of events. And one of those is property tax. So the property tax transaction triggers, or a change or increase in property tax triggers when someone dies. And if you don't actually transfer the asset, now you could owe increased property tax back from the date of death up until current, plus penalties and interest. I've seen too many people lose houses over property tax because they thought mom gave me the house, I don't have to do anything, I'll just wait because it's really hard to do a probate, I don't want to deal with it, and then they end up losing the house. So please move forward with a probate. You're more likely to keep the house and you're less likely to lose it. So to recap, probate is required when there's no trust and assets over $206,000. Not every asset goes through probate, but many common ones do. If one asset has to go through probate, it causes everything else to go through probate. There is no free pass. If one thing has to go through probate, everything else does. If there's no will, the court decides who gets what. And ignoring probate can delay or derail everything. If you're unsure whether your loved one needs a probate, or if you're worried about what steps to take, make sure that you see a certified specialist estate planning attorney. They're really, really good, and they can help you with that. They do it compassionately, carefully, with an eye on avoiding mistakes that cost time, money, or peace. Find a good one because it takes a long time and it's very stressful. If you reached this stage in the video, thank you so much for watching. Be sure to like and subscribe so you never miss a video, and share this video with someone who you think could use the information. We want to help as many people as we can. Make sure you follow along so we can help you develop the keys to your legacy.